So coming off the recent Fifth Circuit En Banc panel ruling, which struck down the ATF's bump stock ban, a new case has been filed by Polymer 80, which seeks to strike down the new ATF rule on frames and receivers. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year. Kershaw produces a broad range of knives to meet every single person's needs. You can get a $20 Walmart knife, and you can also find $200 US made automatic knives. And just recently, Kershaw dropped their new 2023 line of knives, including a US made automatic knife. Kershaw always makes high quality, durable, and aesthetically pleasing knives. I highly recommend their knives. I use one of them every single day for my EDC. And right now, if you order and you use the code 20Scholar, you can get 20% off of your order and also free shipping on orders over $100 or more. So again, head over to Kershaw Knives, use that code, and thank you again to Kershaw Knives for sponsoring this video. As I mentioned in the intro, in this video, we will be discussing another major lawsuit that was just filed against the ATF and their recent final rule regulating unfinished frames and receivers. The case we're going to be talking about in this video is called Polymer 80 versus Garland. This is a lawsuit filed in the Northern District of Texas against the ATF and is going to go before the same judge, Judge Reed O'Connor, who you may recall recently ruled in another case called the Vanderstock case, and he ruled in a way that actually once again halted the ATF's new rule on frames and receivers. Now, if you're not aware of what this lawsuit entails or what this issue is, this is a lawsuit against the ATF because of their new rule on frames and receivers that they dropped and went into effect in August. This new rule by the ATF is essentially a restriction on the sale of 80%ers. Under this new rule, 80%ers are treated to actually be firearms. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references so that now 80%ers are actually included in that GCA definition of a firearm. Since 80%ers are treated to be firearms, they are now subject to serialization requirements and background checks as well. In this case, Polymer 80 is challenging the final rule on frames and receivers and the ATF's recent open letter on that issue. Polymer 80 states that this lawsuit challenges the Biden administration's unlawful attempt to unilaterally rewrite federal law, create a new criminal and civil liability, destroying the ability of Americans to exercise their Second Amendment rights by privately making firearms, and infringe the First Amendment rights of plaintiffs, Polymer 80, to market and sell the lawful product targeted by the Biden administration. In this lawsuit, Polymer 80 argues that the ATF is impermissibly expanding the definition of frame and receiver under the Gun Control Act, also known as the GCA. They are expanding that definition so that they can now treat even unfinished frames and receivers, which are sold on their own, as actual firearms. And that fact is also evidenced by the recent open letter that the ATF sent out, which specifically targets Polymer 80, and they are named specifically in that letter. In the open letter, the ATF stated, applying the regulatory text of the final rule 2021-05F, partially complete Polymer 80, Lone Wolf, and similar striker-fired semi-automatic pistol frames, including, but not limited to, those sold within parts kits, have reached a stage of manufacture where they may be readily completed, assembled, restored, or otherwise converted to a functional frame. This definition of readily applies to each and every classification of a partially complete frame or receiver under this rule, whether sold alone or as part of a kit. And therefore, under this letter, the ATF stated that even without any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials, these partially complete pistol frames are frames and also firearms, as defined in the GCA and its implementing regulations. So the main takeaway from that open letter was that the ATF is claiming that under the rule, they can regulate partially complete handgun frames like those made by Polymer 80. The ATF claims that they consider those to be firearms, and that is regardless of the fact if the 80%er is sold on its own or with other items like a jig, drill bit, or instructions. Now, this open letter that the ATF sent out is actually contrary to some of the prior documents of the ATF and also recent statements that they've made on this topic in other lawsuits. In fact, in the Vanderstock lawsuit, again, a different challenge to the ATF's frames and receivers rule, the ATF stated in that lawsuit that it likewise remains true that a partially complete frame or receiver alone is not a frame or receiver if it still requires performance of certain machining operations. Accordingly, under the rule, companies that sell or distribute only unfinished frame or receiver billets or blanks, and not any associated jigs, templates, or similar tools to the same customer, are not required to be licensed or to mark those articles with identifying information. So even after the new rule went into effect in August, in this lawsuit against the ATF in fact said that if these items are sold on their own without jigs or instructions, they do not fall under the purview of this final rule on frames and receivers. However, now all of a sudden, they are saying that they do fall under the regulation, even if they're sold on their own. And in this letter, they specifically target Polymer 80 and another company called Lone Wolf. Polymer 80 in this lawsuit is seeking for the court to declare that the final rule and the open letter is in fact unlawful. They are also likely going to seek some sort of preliminary injunction to halt the enforcement of the new rule, which is being enforced against them and their customers. This lawsuit will also likely piggyback off of the recent Fifth Circuit En Banc panel bump stock ruling and that decision in Cargill. In that case, the Fifth Circuit recently struck down the ATF's final rule banning bump stocks and regulating bump stocks as actual machine guns. In that case, the En Banc panel in the Fifth Circuit found that the GCA's definition of machine gun was very clear, and that clear definition did not include those items' bump stocks. They also ruled that Chevron deference should not be granted to the ATF, but if the statute was ambiguous, at the very least, the rule of lenity should be applied instead. If you're not aware of what Chevron deference refers to, Chevron deference is a term coined after a Supreme Court case which refers to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. In contrast to Chevron deference, the rule of lenity indicates that when dealing with a criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to us, the people, not an enforcement agency like the ATF. The En Banc panel in the Fifth Circuit Cargill case found that the interpretation of the definition machine gun does in fact involve criminal penalties, and therefore the rule of lenity would direct the courts to interpret it in a way that's in the favor of us, the people, not the ATF. And now all of this has set the framework for this new lawsuit against the ATF and their new rule against frames and receivers. So it's going to be really interesting to see what ends up coming out of this lawsuit. Like I mentioned, the court here, the judge responsible is going to be Judge Reed O'Connor, who has already issued favorable decisions on this topic and now has the Fifth Circuit's En Banc panel ruling in Cargill, which is even more ammunition for him to rule against the ATF and find that this new rule also is an overreach of the ATF's authority. So this is a case we should definitely be keeping our eyes on. If we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.